This VoiceThread is going to introduce you to the Fourth Amendment. So the Fourth Amendment deals primarily with searches and seizures of physical objects, but also with information, right? So access to information. And as you'll see in these early cases, this is going to be one of the early issues that the court has to address, whether or not, the text of the Fourth Amendment, which is, somewhat outdated in terms of technology, applies not only to papers and effects, but also to other kinds of information. So as we'll see, going through the Fourth Amendment cases, both in this VoiceThread and the next, that ends up being really important, as things like smartphones have become more and more available, right? Like, just think about it. Where do you keep most of your information? Is there, a single place or device that you would, prefer to keep private? Well, in 1910, maybe that would have been like a locked file drawer or a ledger. But today, you carry most of your sensitive information around on your body, right, in the form of your cell phone. So we're going to talk about technology as we move through the Fourth Amendment cases. We're going to talk about the meaning of privacy, right? So this is something we'll revisit later in the course also. But privacy, has to have some kind of meaning within the Fourth Amendment. And then we're going to talk about also the different spaces that the court treats as being different. So as we're going through the Fourth Amendment cases, you're going to pay attention to see if you see any kinds of like tensions or inconsistencies between the ways that things are decided. Here we see on the slide the full text of the Fourth Amendment. Again, like the First Amendment, this is a pretty limited amount of text, right? This is pretty short. It seems fairly straightforward. So it reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." All right. So let's unpack this the same way we have the other amendment that we've looked at. So, all right, the right of the people to be secure in their persons, houses, papers, and effects. So these are physical objects, right? So this is one of the things that the court ends up grappling with. And like fairly late in the game, you'll see this argument reappearing in dissents. So we'll talk about that as we go. But okay, person, so that is yourself, right? So this is stuff that you are carrying, perhaps. So when we think about someone being secure in their person, that means that you can't just be stopped, right, on the street and searched without some sort of reasoning for it, right? No one can go through your pockets. They can't go through your bag. Houses, that seems pretty obvious, right? But, what if you live in a dormitory? What if you live in an RV, right? What if you live in your car? Now, papers ends up really being the sort of like troublesome one for the court, because papers, like at the time when the framers wrote the Fourth Amendment, papers meant exactly that, papers, stuff that you would write your information on. But now we don't really write most of our vital information on papers. Instead, we store it electronically. Okay, and effects, right? So that's, again, just your stuff, right? So that can refer to all sorts of things. Like, is your car one of your effects? What about a shed that's standing on your property or undeveloped property? All right, so we'll talk about all of these things. And the court ends up trying to kind of like work out exactly how the Fourth Amendment applies to all of these different circumstances. Okay, so against unreasonable searches and seizures. Okay, what's an unreasonable search or seizure? Well, there has to be some kind of cause for it, right? They use this term in the next bit, probable cause. So there has to be some kind of evidence, right? So they say supported by oath or affirmation. That implies that some kind of evidence is going in front of some kind of judge, right? Who's going to either say this is sufficient evidence for a search or it's not. All right, and particularly describing the place to be searched and the persons or things to be seized. So we see this on search warrants, right? If you read a search warrant, it will say a particular place, and it'll list the things that they're looking for, right? The authorities can't just go through your house, kind of on a fishing expedition to see what they can find. All right, so why might the framers have chosen these particular things to include in the Fourth Amendment? What are the concerns that are behind them? Well, first of all, we'll see this same worry that we saw arise in the First Amendment with arbitrary government power, right? We don't want government officials making decisions that aren't justified, right? We don't want them, for instance, targeting unpopular or minority groups in using their rights, and especially in the criminal context, because the powers that authorities have are far-reaching, and the consequences of being caught up in them are really serious. Right? So there's this concern about constraining government action again, right? Making sure it isn't arbitrary, that there's some kind of justification, that power has been checked. Arguably, and we'll discuss this, but arguably there's also an expectation of privacy, right? We might even say a right to privacy built into the Fourth Amendment. It specifies your house. Your house should be a place where you are safe, where you have some expectation of privacy. Well, as we will see with the cases, the court has to work all of this out through different circumstances that come before them. A couple of big questions to consider. All right, so as we've discussed, the Bill of Rights is fairly limited. The framers put a good deal of thought into what to include in it, and it's supposed to protect our basic freedoms, our basic rights and freedoms. So what were the framers protecting us from, right? So in the last slide, I mentioned, obviously, arbitrary government action. But, when we're looking at searches and seizures, this is particularly intrusive action, right? So again, it might be, having your pockets searched. It might have someone coming into your home or business and going through your stuff. So we're looking at potentially serious intrusions. But consider too, what are the other potential harms with searches and seizures? So first, what actually constitutes a search? Do government agents actually have to set foot on your property and physically handle your things for that to be a search? What about just accessing your information? What about accessing information that you've already shared with someone else, right? So for instance, you probably have a bank account. Well, you've given that bank an awful lot of access to sensitive information about your finances. And I mean, if you're willing to share it with Wells Fargo, why aren't you willing to share it with the authorities? Should you really expect that it's still private once you've shared it with your bank? What about with your utility company? All right, so what constitutes a search? So relatedly, what about a seizure? This comes from literally the term seize, so taking a thing and carrying it away. Initially, when the framers were writing the Fourth Amendment, they were talking about, security in your papers and effects. Well, a seizure could really be, an interruption to your regular activities if, an authority figure hauled off one of your ledgers or hauled off papers that you needed. The issue wasn't only that now the government had access to your information. The issue was also that you didn't have access to it anymore, right? So you didn't have exclusive access to your property, but also you may not be able to use it. So are we looking at a different set of harms when it comes to seizing things than we are when we look at searches, right? So one thing that we'll discuss on the discussion board is the harm in asset forfeiture, right? So there was a big case in front of the court in 2019 about civil asset forfeiture, right? So this deals with a type of seizing, right, that actually takes place under the Fifth Amendment's taking. But are the harms in seizures different from the harms in searches, or are they related? So ultimately, what is the Constitution protecting us from under the Fourth Amendment? In the first set of readings on the Fourth Amendment, you will have covered these cases, and especially cats, in some detail. So I'm just going to touch on these, though, because they are important in terms of framing the kinds of questions that the Fourth Amendment asks. So the first case we're going to look at is Olmstead versus United States. And so this is a case from 1928. So it's a very early wiretapping case, right? So it deals with government agents gaining access to a conversation being conducted via phone. So the court is here presented with a relatively new technology, and they're trying to figure out how to fit it into this Fourth Amendment framework that up to this point was really fairly limited. So your book covers the facts of Olmsted, but as I said, this is an issue of access to information, right? Do you necessarily want government agents to be able to tap your phone and listen to your phone conversations without your permission? Well, one of the questions that the court asks in Olmsted is that even a search? What are we concerned with here? Is it some kind of sphere of privacy, or is it only a search if you no longer have exclusive access to your information, right? So in this case, like Olmsted wasn't losing access to his phone conversations. He could still, engage in his business, legal or illegal, but it was going on with access on the part of government agents. And so the court looks at this and says, is this even ultimately a search? So one of the lines that the court draws in Olmsted versus United States is in asking exactly the question I was just asking in the last slides. What's the harm, right? What is the potential harm that the Fourth Amendment is protecting the citizens from? And they settle on the logic of trespass. So trespass, you're all probably familiar with the term trespass and trespassing. This is an idea that comes to us from the common law. When I refer to the common law, by the way, that is just to say case law that has evolved over the years, right? So it's built by precedent. And so this is made more by practice than, by fiat, right? It's more a matter of kind of evolving from what people do than someone sitting down and writing it out, although, it will eventually be codified. So the idea of trespass comes from the common law, right? And it has to do with people being where they don't belong. Someone being on your property who doesn't have permission. So one of the questions is, access or exclusivity of the use of your property, right? So generally, if you own something, you get to decide who has access to it and who doesn't. And so the court settles on this idea of trespass. They say, okay, look, the harm that the Fourth Amendment is trying to protect people from isn't necessarily some broad right of privacy, but rather, right, what the court is concerned about is controlling government trespass into people's private spaces. And so they use this term, go ahead, laugh it up, the physical penetration rule, right? And so that refers to the actual physical presence of government agents on a person's property. And so, as long as they're tapping a wire that isn't located on the property of the person they're investigating, the court says this is fine. So there's an important dissent from Brandeis here, right? You're probably at this point seeing a pattern. Brandeis's dissents tend to be important, right? So he is a very influential former Supreme Court justice for this reason. And so Brandeis completely rejects the whole idea of trespass, and he introduces instead this idea that ends up being the single most important idea in Fourth Amendment jurisprudence, which is the reasonable expectation of privacy. Now, that said, in Olmsted, this is Brandeis's dissent, so it isn't part of the opinion. All right, so this brings us to Katz versus United States. So Katz versus United States, this is 30 years later. This is when the court finally revisits this ruling that they held in Olmsted. Now, this is one of those rare cases in which the court is actually going to overturn their prior ruling. So they overturn Olmsted and then a related case, Goldman versus US, that had to do with a now defunct technology for listening through walls. But as the court revisits this question of the right to privacy, they say, look, we actually need to adjust how we think about the Fourth Amendment. And part of the reason for this was that the court had, created, discovered, constructed, however you want to phrase this, the right to privacy through the Ninth Amendment in Griswold versus Connecticut 2 years earlier. So there are a couple of important points that come out of this, but I'm going to say a little bit about the facts first. Okay, so Katz versus United States, 1967. So FBI agents suspected that Charles Katz was engaging in illegal bookmaking activities. Now, bookmaking is related to betting, right, or gambling, specifically, generally illegal, right? So illegal bookmaking activities. Specifically, they thought that he was using the telephone to relay bets and wagering information. So to gather evidence, they placed listening devices outside the telephone booth, right? So telephone booths are another one of these old technologies you may or may not have seen around, but these are generally like glass booths, right? So you can see people in the booth. The idea behind the booth is to shelter them, in the person using the phone, from the elements, but also to shelter, to give some privacy, right? So to contain the sound, essentially, of what they're saying on the phone. So the fact that there's a phone booth involved here ends up being important. Okay, so to gather evidence, they placed listening devices outside of the telephone booth that Katz used to make his calls. So ultimately, they used this evidence to gather an 8-count indictment against Katz. So the legal question that comes up is a person protected by the Fourth Amendment when he seeks to preserve his privacy, even in an area accessible to the public? And the holding is yes. So 7-1, the court ruled in favor of Katz. All right, so is a person protected by the Fourth Amendment when they seek to preserve their privacy, even in an area accessible to the public? One of the important points here about this being in a phone booth is that this is public, right? So these were things that anyone could go into, put in a couple of coins and make a call, right? So they were owned by phone companies, but they weren't owned by private individuals, right? So Katz did not own this. There's no way that that government agents were, trespassing onto Katz's property, to apply the logic from Olmsted. All right. So first of all, the court kind of like reframes the decision, reframes the question. So they reject the idea of, quote unquote, a constitutionally protected area, right? And this was part of how the case was brought to the court. The question was, is a public phone booth a constitutionally protected area? So first of all, they say that they're going to reject the idea of a constitutionally protected area. But second, and remember this for when we get to civil rights at the end of the class. Second, the decision in Katz actually says there is no general constitutional right to privacy that we can derive from the Fourth Amendment. Okay, which that's important because at this point, as I said, they had already found a right to privacy in Griswold, but they find it not through the Fourth Amendment, but the Ninth. All right. So they reject the idea that the Fourth Amendment confers a general right to privacy. So the government argues that the phone booth here, because it was partly made of glass and Katz was visible, that he, did not have a reasonable expectation of privacy. But the court also rejects that reasoning and says, and I quote, "What he sought to exclude was not the intruding eye, but the uninvited ear." So what's going on here conceptually is that the court doesn't want to have like a binary in terms of you have an expectation of privacy or you don't, right? They don't want to say that just because you're visible, that doesn't mean that you have absolutely no expectation of privacy in a phone booth. Rather, they're going to kind of scale it and say, in this case, the clear purpose of the booth is to contain sound. So, he had an expectation that he wasn't going to be eavesdropped on. So the government argued, according to Olmsted, that because the agents did not, quote unquote, penetrate the booth, that they didn't walk into it, right, like while Katz was using it, that because of that, the Fourth Amendment shouldn't apply here. And so this is where the court specifically rejects Olmsted, right, and also Goldman. And so as it's put in the decision, the trespass doctrine had been so eroded, right, by cases that had been decided between Olmsted in 1928 and this case in 1967, that this logic of trespass no longer makes sense. And they point out, like trespass can't cover the new technologies, right, that we're seeing in the 20th century. So they say specifically that electronically listening to the petitioner, that's Katz's conversation, constituted a search and seizure under the Fourth Amendment. The fact that they did not go into the booth, that there was no, foot set on the property is irrelevant. So the key idea that comes out of Katz is here. So they say in the decision, the person is protected and not simply the area, right? So the Fourth Amendment protects persons, not places. And this is the key finding. All right, so they say, generally speaking, these searches would be legal if they had, a warrant, but this search cannot go forward without a warrant. It's a violation of the Fourth Amendment because, again, the Fourth Amendment protects persons, not places, and Katz had a reasonable expectation of privacy. All right, so there are a couple of dissents to this. Black, particularly, take a look at Black. He says, look, there's no general rights protected by the Fourth Amendment. This just doesn't apply to what he calls eavesdropping. So eavesdropping is also an idea that comes from the common law. And so this was a common law tort. Remember, we talked about torts when we talked about libel, so this was like a civil wrong. Eavesdropping, according to the common law, was it was a wrong, but it wasn't like a major wrong. And it simply consisted of listening into a conversation that you did not have permission to be part of. So Black says that's all that happened here, right? So Black says okay, well, the agents were out of line, they were eavesdropping, but there's no Fourth Amendment protection against eavesdropping. So Black is way out of line here, honestly, with where the Fourth Amendment ends up going. Black wants to say basically that electronic communications are not covered. Harlan is actually much closer to where the Fourth Amendment ends up going, right? So he talks about the quote unquote reasonable expectation of privacy being key and not necessarily the place or the features of the place. All right, so Katz is an important case. Make sure that you have a good grip on it because it ends up kind of being the pivot point for a lot of later Fourth Amendment cases. All right, so quick recap. For some reason, VoiceThread has turned my arrows into little moons. That's fine. So in Olmstead, the court put this emphasis on physical presence in a space, right? So they were arguing about certain spaces being constitutionally protected or not. And so they're using this trespass logic. So the court only also treated physical effects, so documents, images, objects, as subject to protection and not conversations. So later, obviously, the court moves away from essentially everything in Olmstead. In Katz, there's now this introduction of eavesdropping, but they say actually eavesdropping isn't just a common law tort, that is a violation of your Fourth Amendment rights. Because those roots those rights are rooted not just in exclusivity of access to property, but also in a reasonable expectation of privacy, right? And those rights are centered on people, not places. So this seems like a pretty clean break, right? So Katz seems to have gone in a completely different direction from Olmstead, and it seems to have signaled, a totally different direction that the court is going to go in. Now, this gets a bit more complicated, though. It's easy to say that the Fourth Amendment guarantees a reasonable expectation of privacy and that that's centered on people, not places. But also there are certain places where you have a more reasonable expectation of privacy than others, right? So if you're on your cell phone, walking down the street, talking, you don't really have much of an expectation of privacy, even though you are, on your device speaking to one other person, you're out walking around in public. By contrast, just think about your attitude toward your home. Think about how, how egregious a violation it would seem like if you, got home and found out someone had been digging through your stuff without your permission, right? So we have a very high expectation of privacy in our homes that we don't necessarily have elsewhere. So the court actually ends up not sort of hewing too closely to this distinction that they're drawing in Katz between people and places, because it turns out that, places are also important. Now that said, they do want to move away from the logic of trespass because that ends up not affording you very much protection, especially for your electronic communications. All right, and so this brings us to Jones, which is a case from 2012, which kind of brings all of these tensions into stark relief. All right, so Jones is an unusual case because we see a seeming return to the trespass logic of Olmstead. All right, so I'm just going to briefly summarize the facts from Jones, even though they're covered pretty well in your case. Okay, so the FBI and the Metropolitan Police Department suspected Jones of cocaine trafficking. So as part of this investigation, officers, they did get a warrant authorizing them to install covertly and to monitor a GPS tracking device that they placed on Jones's Jeep Grand Cherokee. So it was registered to Jones's wife, but used exclusively by him. All right, so the warrant had requirements. The warrant required that the GPS device be installed within a 10-day period. However, the officers installed it not within that period, but on the 14th day. I'm sorry, 11th day. They changed the batteries on the device, and it ended up remaining on the car for 28 days. So over this 4-week period, the device transmitted to the police more than 2,000 pages of data on the car's movements. So it couldn't tell the police who was driving, if there were passengers, or what the driver and passengers did in the car, obviously, or at their destination, but it could tell them where they went, right? It told them all about the car's movements. Based also on intercepted phone calls, police learned that Jones was expecting a shipment of cocaine in October 2005. On October 24th, the police executed search warrants for a number of locations. So after an initial trial ending in an acquittal on some charges and a deadlocked jury on others, Jones was indicted on a new charge of conspiracy to distribute cocaine. So despite Jones's objections, the judge allowed the information collected by the GPS device to be admitted as evidence. Jones was then convicted and sentenced to life in prison. He was also ordered to forfeit $1 million in drug proceeds. All right, so there's a lot going on in this case. But the legal question was, does the attachment of a GPS tracking device to an individual's vehicle and subsequent use of that device to monitor the vehicle's movements on public streets constitute a search or seizure under the Fourth Amendment? All right, so the holding was yes, and it was unanimous. So Scalia wrote for the majority. All right, so there's a little bit there are a few different arguments made here. So number one, the government physically occupied private property for the purpose of obtaining information, right? So they say that they have no doubt that such a physical intrusion would have been considered a search within the meaning of the Fourth Amendment when it was adopted. As an aside, mind you, this is Scalia writing the opinion. Scalia is an originalist, right? So an originalist is someone who interprets the Constitution as meaning specifically what the founders intended, right? So for an originalist, the founders' intentions are the question that we should be asking. And you can really see this in Scalia's opinion. Okay, so physical intrusion into private property. This sounds, again, a lot like trespass. Number two, the text of the Fourth Amendment reflects its close connections to property, since otherwise it would have referred simply to, and I quote, the right of the people to be secure against unreasonable searches and seizures. However, if it weren't intended to reach property, the phrase in their persons, houses, papers, and effects would have been superfluous. All right, so Scalia goes on to say that in Katz, the court had decided that the Fourth Amendment protects people and not places, and found a violation, in the attachment of an eavesdropping device to a public telephone booth. However, he says that later cases have applied the analysis that comes out of Harlan's concurrence to Katz, which says that a violation occurs when government officers violate, and I quote, a person's reasonable expectation of privacy, end quote. However, right, Jones's Fourth Amendment rights do not, they're not limited by the Katz formulation, right? So Scalia says Katz is still good law, but it's not everything. He says at bottom, we must preserve the dignity of privacy against government. And as he puts it, and I quote, that existed when the Fourth Amendment was adopted. Right, so he says, yes, the Katz reasonable expectation of privacy test has been added to, but, Katz doesn't completely substitute or supersede all common law restrictions either, right? So the way that Scalia formulates this, he's saying that, yes, Katz is still good law, but it's Katz plus is one way to think of this. So, yes, the Fourth Amendment protects people and not places, but also, right, like we see the trespass logic return. So the Fourth Amendment also does protect places. So he differs from some of the concurrences, right? So Sotomayor writes a concurrence, Alito writes a concurrence, but he differs from some of the concurrences in saying, that Sotomayor and Alito might make cats the exclusive test, but he says trespass is not the exclusive test. So situations involving only the transmission of electronic signals without trespass will remain subject to Katz analysis, right? That means reasonable expectation of privacy, persons, not places. However, Scalia isn't willing to give up trespass and eavesdropping. All right. So usually when the court comes up with a new test that, just totally displaces the old test, but Scalia is very clear here to say we are not overturning Katz, right? We are going to keep Katz, we're just going to add to it. Okay. So one question I want to ask is, given what you know about how your cell phone and your other devices track your movements, do you think the reasonable person standard is significantly different today from what it would have been in, say, 1967 with Katz, or even US v. Jones, right, in 2012? We know that our devices track us. Open up any of your apps that are owned by Google, and often even if you disable the tracking functions, they're still tracking you. So we kind of know that we are carrying around these surveillance devices, these self-surveillance devices. So should the court adjust their reasonable expectation of privacy, test accordingly, or do you think that would be a step in the wrong direction? Right, so please go ahead and post on the discussion board about that. I think this is a really tough question because we do all know, right? We know that it's possible that our phones are tracking us. So Jones probably, could have thought of this, that his cell phone was tracking him, even if he didn't expect a GPS to be attached to his car. And, with modern smartphones, it's not as easy to disable the tracking functions as it used to be. For instance, you can't just open them up and take out the battery. That isn't necessarily going to do it, or you may not be able to do that. All right, so I'm interested in seeing what you have to say about that on the discussion board. Just for the sake of length, I'm going to conclude this voice thread here, but I'm going to point to some of the things that we'll discuss in the next voice thread. So, as we've kind of seen foreshadowed from these cases, on the one hand, yes, you have Fourth Amendment rights that attach to your person, to you. On the other hand, there are certain places, as we saw in both Katz and Jones, where that expectation of privacy might vary, right? So the court still thinks places matter. So specifically, we will talk about automobiles in the next voice thread because these present yet another challenge, right? So these are, a technological innovation that the founders could not have foreseen, although, they had carriages then. But, they have important features. So like the phone booth in Katz, you can see in all the windows. So should you necessarily have a reasonable expectation of privacy in your automobile? They also move around, right? They don't stay in one place. And so they have this potential for, destroying evidence that a house doesn't have. All right, so these are private property. They're taken out on the public streets. What is the status of a car? So we'll look at this next time, but, just spoiler alert, it is reduced, right? So it's not that you have no expectation of privacy in your car, but it's not as much as you would have in, say, your house. Now, that said, there are a slew of cases in which the court has refined this that we will touch on next time, and that your book actually summarizes, I think, really well. But that's what we will discuss in the Fourth Amendment 2.